Okay, so thank you for participating in the first activity, and I hope that you had an opportunity to learn from each other. That's the part of today's experience that I know the least about. So you all know the most about that, and that's why I wanted to offload the responsibility onto you and crowdsource that game. So thank goodness you did a great job. So this one's to you. Well done. Excellent. All right, and then I guess the title of my talk is supposed to be about intellectual property. So that's what we're going to kind of dive into. Now, I'm not really an artist. You're going to find that out immediately. Okay. So anyway, I want to talk about knowledge and different views of knowledge. So this is a tree. So as far as, let's say, Indigenous knowledges and knowledge systems, Canada, who doesn't always get it right here, but Canada tends to break it up into three different groups of knowledge within Indigenous people's knowledge systems or Indigenous people's protocols. So in Canada, they say you got TK, which is traditional knowledge, right? They say TCEs, they call that traditional cultural expressions. So that's stuff you can hold. And maybe it's basket weaving, maybe it's drum, maybe it's art, maybe, anyway, things you can hold. And the last thing they say is GRs. That's genetic resources, or BC, it's biocultural knowledge. That means plant knowledge, right, or environmental knowledge. So that's what Canada says, right? Indigenous people's knowledge, ancestral knowledge, it usually fits in these three areas, okay? Well, that's kind of the roots of the knowledge tree that I'm about to describe here, okay? So that's one, okay? These types of knowledges are governed by, well, IP. That's Indigenous protocols, okay? So anyway, so there's IP, that IP, and there's another IP, and that's intellectual property. And then there's another IP. What's the third IP?
Address people?
What's that?
IP address?
Your IP address, yeah, so we're gonna get to that in a second. We got multiple IPs here. Okay, so I'm gonna draw this tree here, and this is gonna be a knowledge tree. Bear with me for a second. Again, I'm not an artist, but this is a knowledge tree. Okay, so most Indigenous people's knowledges would fit into an intellectual property category. They call it trade secrets, or secret, sacred, or sensitive knowledges. Okay, so in Canada they call it trade secrets. In the States they call it trade secrets also. But it's knowledge that not everybody knows. It's often in a database as well. It's trade secrets. Now there's another category of intellectual property called trademarks. We're not going to talk too much about trademarks today, but if you wanted to talk more about it, I would love to. Trademarks, typically that's for more commercial knowledge. However, so trademark, I don't know if I'm wearing some trademark stuff right now. So this is Dakota brand shoes, right? That's a trademark. Or Disney, they've had that trademark for quite a while, of course. So trade secrets and trademarks, these are both things that last forever. Okay, they have infinite protections. Trade secrets is until that secret is revealed, and trademarks you just keep reapplying about every 15 years or so. Actually, in Canada, when you have a domain name, like a URL, that actually can be that's put in a trademark law. So you can say, oh, I've been using this for a while, it's a trademark. And actually I was visiting with the CRTC not too long ago when Phil's group had invited me up to Musqueam, and the CRTC said, okay, we just launched it, you can actually use syllabics in your URL, which I found.
Universal acceptance.
Yeah, and so they said they haven't heard of anyone using it yet, but they said that it is an option, which I found really interesting.
They're trying to do that.
Yeah.
Not quite there yet.
Okay.
Yeah.
So looking for kind of a few pilot groups. Yeah. Okay. Now there's lots of areas within trademarks. Okay. There's a trade dress. There's a collective mark. There's a certification mark. There's geographical indicators. If you're an Indigenous tourism group in so-called Canada, you can use a logo called, quote, original, that certifies you as an Indigenous tourism outlet, original, which is really interesting. Within trade secrets, Within trade secrets, again, I mentioned databases, but a lot of your groups were talking about contracts. You're talking about NDAs, that's non-disclosure agreements. You might have confidentiality agreements. You might have non-compete agreements as well. Those all fit within trade secrets. Secret, sacred, or sensitive knowledges all fit within trade secrets. And here's the thing, right? If trade secrets is kind of like a recipe, right? So like KFC's 11 herbs and spices, right? That's a trade secret. They're not supposed to know what those are. But you can, and other groups can, reverse engineer trade secrets, okay? So Canada defines trade secrets as knowledge which you can make money off of. If you can't make money off of it, then it's not a trade secret. We're going to revisit this in a second here, because Canada doesn't always have it right. In fact, it gets it wrong a lot of the time. So next, we're going to talk about copyright, right? So that's a circle C, and patent. Okay, so copyright, very recently, copyright has been extended in Canada from 50 years after your death to 70 years after your death. Meaning, right, everyone here, you created copyrighted content this morning, right? Pretty much every day you're creating your own copyrighted content. In Canada, you don't have to file for copyright, it's automatically granted. So if you write down an original idea, that's your copyright, right? If you've ever written a journal diary entry, or you've ever written a poem, or you've ever just like drawn a tree or whatever, that's your copyright. You own it automatically if it's an original idea. Now, copyright's really fascinating because it has an expiry date, right? Trade secrets and trademarks don't expire, copyright and patent do. So copyright is 70 years after your death, okay? And that's when Canada joined the USMCA. It extended our copyright. Now, also fascinating in the USMCA is there's a special section that addresses Indigenous people's rights. And so if you're looking for that section, I can validate what that section is, but this is a multi-nation trade agreement. And so in there, they make it quite clear that the USMCA does not override Indigenous people's rights, inherent rights. So there's a lot to be unpacked there. So anyway, kind of within the space of copyright, copyright is really kind of ambiguous. There's things called moral rights. That's your decision-making power behind something. And your economic rights.
The moral is around the interpretation of the work.
Yeah, so if, okay, so this game, Data Dice, okay, technically I have the copyright, but I'm like, yeah, you go ahead and you use it, right? That's my moral rights. You can never sign away your moral rights. For example, somebody, an anthropologist, a linguist, whoever comes to your community, and they start recording elders' knowledge, the person who pressed record is the person who owns the copyright, not the knowledge holder, not the elder, not the expert, not the language speaker, etc. It's the person who presses record. Okay, and so that person who presses record has moral rights and economic rights. But did we agree to that? No, right? And so, so economic rights can be signed away, moral rights cannot. So I created that game, Data Dice, whatever, and I'm like, yeah, you go ahead and use it. But let's say one of you, take that and then you turn it into a real game, and it's on a game show and it's on TV. Not that it would ever get there, but then you start profiting off of it, or you start using it in ways that I did not give you permission for, right? They started going against the moral rights. We've got a claim here. Now, so let's say, there are many governments, many Indigenous governments who are in the process of rematriation, who are in the process of getting their materials back. Well, there's this woman, Dr. Andrea Bear-Nicholas of the Maliseet community, and there were thousands of pages of transcribed Maliseet, okay, that were done by a professor in the 70s, 80s, and 90s. So then that professor, they got in a big legal battle. And so the community asked the professor, hey, like, our language is endangered. We need our language materials back. And he said, no, those are mine. Because and technically in Canada, he has the copyright, right? So, so then the community was like, well, what would it take for us to get those materials back from you? And then finally the Maliseet community put forward a number. I don't know what that number is. It's probably, I don't know, somewhere around $20,000 to $30,000. And then so they made a deal with the guy, which was, okay, we'll give you $20,000, you give us those transcripts. However, moral and economic rights, okay? So they gave him the money, he gave the transcripts, but he did not, so he rematriated, but did not reattribute the copyright to the community. Meaning the community got the papers, but they couldn't create materials with it. They couldn't create new copyrighted works because they were still the copyright of the other person. So they had the originals, but they couldn't make anything with it. So what did the community do? They stopped asking for permission. They stopped caring about the law. They said, it's more important for us to just create resources, sue us. If you want to sue us so bad, sue us. So they had the originals. Even though they were breaking the law, they just went for it. And honestly, I'm on that side. Yeah, I'm not trying to tell you to break the law, but sometimes you have to, right? So, yeah. Yeah, okay, good. This is far different than the academic conferences I'm a part of. So, okay, so that's a little bit about copyright. Patent, so patent has to do with the novel invention of utility. Patent can include products, processes, algorithms, and compositions, okay? Often if you, let's say, anyone here into fashion? Yeah, okay, right. So if you buy like a Louis Vuitton bag, it's often, I mean, yes, you're paying for the trade dress, but you'll notice that the clasps on those bags are usually very unique.
You're really paying for the branding for a lot of luxury products.
For the branding and the patent, so they'll have a novel way of opening the bag, and that's how they keep it not easily reproducible. Okay? So versus the logo, yeah. So those are two separate competing things. Now patent I don't know too much about, but in terms of red team, in terms of threats, there's bioprospecting, bioharvesting, and biopiracy. That's like pharmaceutical folks who are coming to communities saying, oh, how do you use that plant? Oh, you mix that with skincare and that's really good. It's anti-carcinogenic, huh? And then they go and they create this medicine, they patent it, and they've excluded your community. That's bioharvesting, bioprospecting, and biopiracy. Since
You're allowed to get away with that.
well, because these laws don't serve Indigenous peoples as much as they do commercial interests. Yeah, right?
And then you need to pursue it, right? You need the resource to defend it.
Yeah. So from a database patent response, here's something that's really interesting. Around the world, in India, there's something called the TKDL, and that's the Traditional Knowledge Digital Library. And so they have laws in India. There's more than there's several hundred distinct Indigenous groups in India. And so you can go to tkdl.res.in, and that's the Traditional Knowledge Digital Library. And so they have there more than like 4,000 different medicines. Of course, you're not going to have access to it, okay? They'll have like maybe, I think, a dozen are public, but the rest are private. So if somebody in India tries to file a patent using traditional Indian medicine, what they've done in India, they have this prior art database. So if somebody goes and makes a medicine, then they get the person to sign an NDA, and they say, all right, this is actually a traditional Indigenous medicine, and you're not allowed to profit off of it. This is our example of prior art, and so that's in their database, which is really interesting from a patent perspective. Another aspect of this tree, I don't know much about it, and that's integrated circuit topography. So that means as you're developing new circuits or new computer mechanics, whichever, is how do you get these pieces to speak to each other? And so that's how sometimes you'll have like on a hair's breadth, you might have 20 different patents, like on a super small like microprocessor or whichever. So you have 20 different interacting technologies or more. Now I don't know much about that, right? Another here would be plant rights, right? Plant breeders' rights. So if you create a new tree or a new bush, there's rights associated with that. Of course, there's seed rights. We can talk about that a little bit. Now, there's two things I really want to talk about with you, and they are intellectual property for land protection or land defense, and intellectual property and data sovereignty. Okay. So first, I'm going to give you that teaser on intellectual property and land defense. So here they are. So here's some examples. So the Delgamuukw case, right? Delgamuukw versus British Columbia, 1997. This is the first time in the Supreme Court that that story was used to validate a land claim. Okay, and so it was the first time that that land title was granted in the Supreme Court, and it was the first time that that story and song was used. Okay, so what is data? Well, data can be anything, and to OCAP and to the FNIGC, data was, and there was a data response for blood theft and blood misuse. So Indigenous people's blood was misused. So anyway, you just have to kind of really open your mind as to what data is, as I'm sure you each have. So anyway, Delgamuukw and intellectual property as land defense, song as land defense. Then there's Stoney, that's a Nakota Nation, who has been using geographical indicators to secure place names. Geographical indicators falls under trademarks. So if you have a geographical indicator, so like Alberta beef would be one, yeah?
Sorry, I'm really curious because right there you have like a cedar tree strip.
Yes.
Right away, like, sorry, what did you say GI stands for?
Okay, so that's a separate one.
Geographical indicator.
Yeah, so we'll get to the CMTs in a second. So a geographical indicator, that says where something is from. It's land-based. Alberta beef is one example, right? What's that?
Taku salmon. Taku wild salmon.
Oh, yeah, exactly, right. If it's from that region, so it's very specific. Yeah, Trish?
So for instance, like it just made me think about a geographical indicator for the taku.
Yeah.
Tell me if this might be right, because remember we saw Wayne Carlick briefly, he like helped us with the canoe. So Wayne Carlick creates like little cedar little carvings on the trees all along the trails. So like all over the watershed, there's all these traditional West Coast art carvings like right on the trees. So would that be an example of a geographical indicator?
So we'll get to that one very shortly. Okay. So that's CMTs. So GIs, that's geographical indicators, and so like if you go and get coffee, for example, and it says Peruvian coffee or whichever, and that says exactly where that coffee's from. Well, you can't say it's Peruvian coffee if it was made in Algeria or if it was made in a different.
So like John said, then like it taproot or salmon.
Yes, yeah. So that is, now often GIs is used for, again, commercial interests, so it's people trying to profit off of it, but this is an instance where they've used geographical indicators as place names, for place names maps, so something to consider. Now, let's get to that example you were just raising. CMTs, that stands for culturally modified trees. Okay, yeah, and this is data. So now in so-called Canada, there's, if you know that there is a tree that had been modified and that tree is older than 1846, then you've got a number of different options. But basically Canada has the interest to protect that area as a culturally designated area. Now, there's more than 60 different kinds of IPCAs, that's Indigenous Protected and Conserved Areas, and each of them have different terms. So if you do have a CMT that's older than 1846 in your region, and there's a lot of communities that do, is you really have to have a conversation, do we want them to know that this is an area that we want to protect, and what does protection mean? Because if it's, let's say, a UNESCO protected site, you might lose some harvesting rights, right? So that's part of the deliberation there. Yeah, so anyway, something to consider. Now this story is hilarious. Okay, Peter von Tiesenhausen, has anyone heard of the guy?
No.
Okay, he's an artist in like central northern Alberta. And so I was in this art gallery and there's this like massive tree, like it's 30, 40 feet long, just wide, you can't hug around this tree. And it's in this art gallery. Like, what is going on here? It's like a tree, he didn't carve it or anything, right? So this is a guy who fancies calling himself an artist, and he's made money as an artist, so we'll call him a professional. And he's down with Indigenous issues, like he's pretty cool with stuff like that. So anyway, he has got a farmland, and there was oil and gas company looking to develop on that land. okay? And so he didn't have subsurface rights or anything like that, right? So they recognized it as being of economic interest to the federal government, whichever. And so, so they're like, all right, we're going to develop, and we're going to have to go right through your land. Sorry, we're going to compensate you for that, right? Now he said, and so the consultants come up and they knock on his door, doot. So then he opens the door and he says, you can talk to me for as long as you want, but I charge $500 an hour. So they talked to him for 3 hours, and he said, nope, and sent them a bill for $1,500. Okay, so that's how that started. But then they exercised it a bit higher, and they said, no, this is a federal economic interest. This is of interest to the state. So he's an artist. You know what he did? He dragged that tree onto his property right in the way of where they were going to develop, and he left it there. And he said, that is art. What I've done with that tree to drag it in the way, it didn't matter. He didn't carve it one bit. He didn't make it his, like, it's just, he moved the tree artistically. And so, and so they could not develop on that land because he has a copyrighted work in the way. So something to consider. So that's intellectual property for land defense. And then I guess I wanted to end on a note, or several notes, of interactions of data sovereignty and intellectual property. So who here has heard of the FNIGC?
I have.
Okay, a small handful of folks, okay. All right, so the FNIGC, they were responding to issues of blood theft. Let's see if I have an example of that. No. So anyway, there were some researchers in the 80s and 90s, and they were visiting with a community not too far from here, actually, Jerry, I'm sure you know the community. And so this researcher was testing arthritis, testing about cases of arthritis. And so had gone into communities, or like one community, and pretty much got everyone's permission, 900 people's permission to gather their blood. I think it's 899 or 898, somewhere in there. So imagine that, okay, hey, can I use your blood? Right, okay, so I'm going around, yeah, I'm using it for arthritis study and taking everyone's blood. Right, you all consented, it's for arthritis study. Wonderful, okay? So I'm gonna do some study, some work, inconclusive. Sorry, nothing for you here, right? But I've still got your blood, and that's what happened, right? So the guy said, yeah, I'm gonna do a study on arthritis, inconclusive study, didn't share it back with the community, kept the blood. So he kept the blood, and now that blood is in a registry in the States where any researcher really can use it without permission. So that blood has been used to see, how does Indigenous people's blood react with HIV? How does Indigenous people's blood compare with blood from people in Eastern Asia? Because you're trying to test the Bering Strait theory. So you're using these people's blood in ways which were not authorized, not with consent, not with protocol, any of that. So, of course, the tensions in the 90s and the an Indian Residential School Settlement Agreement, and a number of these things came out. And then, so what happened was FNIGC formed. That's the First Nations Information Governance Center. And so they were responding specifically to this issue of misuse of Indigenous people's blood or data as blood. And so then they put forward OCAP. So that's ownership, control, access, and possession. And that's an assertion and an affirmation of Indigenous people's rights to own, control, access, and possess their own data. And the prime example that they used here is blood as data. So what is data? Data can be so many things. So within data sovereignty is the affirmation of OCAP. And that's north of 49th. If you go into the States, they would have GIDA. So the equivalent of the FNIGC in the States is GIDA, the Global Indigenous Data Alliance. And they have FAIR and CARE, which are fairly similar policies and assertions. Of course, within data sovereignty is spectrum sovereignty. Within data sovereignty are the examples of rematriation, which I'm sure you're all aware of. But the big counter example, the big addition, the second step, is also reattribution. So it's one thing to receive the data, and it's another to have, let's say, the moral or economic rights of governing that data. But again, moral rights cannot be signed away. So here's what I found yesterday to be really fascinating, is doing just looking it up. So copyright and patent, those are both governed within Section 91 of Canada's Constitution, meaning trade secrets and trademarks are not governed within the jurisdiction of the federal jurisdiction of Canada. Meaning, Indigenous nations can move forward. It's called sui generis. Sui generis means one of a kind. So we can advance our own sacred, secret, or sensitive knowledges, acts, or legislation. Okay? So what happens if people reveal data that they should not have revealed? Okay? We can advance our own trademarks legislation, but again, that's usually more for economic protections. However, there are some examples of trademarks for language protection. So for example, there's the Comox community who trademarked the word Quinish. The word Quinish because somebody who is not a member of that nation was publishing a book using that word, and that word is specific to their creation story. So because they were profiting off of this word that they had no business using, the nation responded and said, okay, that's actually our trademark, and they prevented all further uses of that, which is really interesting.
Like Joseph Boyden through Black Spruce, right, where he used stories from a community.
Yeah.
He claimed to be friends with, and then some of them were sacred stories, and he wrote about them in a fictional book.
That's it.
He profited off hugely successful book.
Yeah.
Some sacred and misinterpreted stories.
That's it. Yeah.
Happens all the time in Hawaii with Disney, Lilo and Stitch.
Yeah.
There's an interesting one too, and during the last production they came and did a LiDAR of the entire island, and then just took it back to Hollywood.
Yeah.
So they just do everything in AI now.
Yeah.
But it's using the topo and...
So I want to leave you with a few thoughts here. These are ones, again, I'm an advisor to several nations on their intellectual property strategies. I have a deferred application for a Master of Laws in Intellectual Property. So it's just an area I love to talk about. So remember, okay, apparently knowledge expires. Okay, according to Canada, knowledge expires. So when you create copyrighted work, your copyright clock starts ticking once you die. Okay, so this is all my copyright. Blech, I croaked. Okay, so 70 years after my death, everything that I have ever copyrighted flows into something called the public domain, which means anybody, anywhere in the world or multiple worlds can use it for any reason. They can profit off of it, they can misinterpret it, it does not matter. Okay? So that's the public domain. What is stopping your nation from having its own domain? So for instance, if knowledge were to ever expire with my nation, with Dene Nation, well, my nation's Northwest Territory Métis Nation, but the nation I'm advising is Dene Nation, would any knowledge flow into a Dene domain rather than a public domain? So something to interrogate. What about if copyright, and again, we've never agreed to copyright, and in fact, we've never signed away our knowledge systems or our knowledge governance systems or our protocols, right? We've never signed into that, never signed away from it. So what if copyright had ad infinitum or infinite protections? Okay, that's an option. Okay. What about, right, the TKDL or prior art in a digital database? Okay, something to consider as a blue team defense against bioprospecting, bioharvesting, biopiracy. So we talked about sui generis or one-of-a-kind trade secrets or sacred, secret, and sensitive knowledges protections. Okay, that's an option. Something to consider, of course, is hereditary data. So what happens if you've got a database, someone's got a database, they pass away, maybe they're a community genealogist, and they pass away. Well, who should that data belong to after, right? So it's a question that Robin R.R. Gray asks around rights of relationality. Yeah, and so she's got a great paper on that. I recommend you read it. In the States, we've got a lot to learn from some of the laws that were passed in the States a while ago here. NAGPRA being one. That's the Native American Graves Protection and Repatriation Act, which Canada does not have equivalent to. Canada does not have an equivalent to the Indian Arts and Culture Indian Arts and Culture Protection Act, yeah, which prevents, let's say, yeah, like you can go to Banff National Park and you can buy a made in China dream catcher, right? And so the Indian Arts and Culture Act would typically prevent against something like that. There's also the Maori Trademarks Act. So if people are filing a trademark in Aotearoa or New Zealand, and if it uses a Maori name, the Maori would have a right to refuse that trademark, right? Kind of like there's a trucking company that uses the word for it's Mantu Trucking, which uses the word for creator, and it's not an Indigenous-owned trucking business, which is interesting. So that would have been prevented. Yeah. Now something else here, again, with regards to intellectual property and land protection and land defense, this is a really interesting area, and I propose something new to this group here. So around the world, there are examples of lakes, rivers, mountains, and forests being granted rights of personhood. So rights of personhood is a collection of rights which includes the right to grow, the right to be free from pollution, the right to sue, which also includes the right to be sued. So, for example, around New Zealand, I think multiple Polynesian nations had recently granted and affirmed rights of personhood to whales and dolphins. And so there are multiple Indigenous nations that have come together to affirm these rights to whales and dolphins. So usually it's multiple groups that come together. Where this all started, rights of personhood, was in the late 1800s. It was actually for a train line because mountains had been bombed through to create this train line, etc. So the owner of the train line was going to eventually die, and of course it has happened since the late 1800s. So who gets the train line? So they granted rights of personhood to the train line. Okay, so it started as an economic goal. But since, and this is in the last 20 years or so, Indigenous nations have taken that idea and said, well, if a train can have rights of personhood, what about whales? What about dolphins? What about the Magpie River in Quebec, right, which was affirmed as having rights of personhood? And so you can look to the, there's 9 specific rights granted to the Magpie River. Again, the right to grow, the right to be free from pollution, the right to sue, the right to be sued. So, yeah, and so, yeah. That's right, if it gets polluted and all that. Now, another example in Canada would be at the Canadian Human Rights Museum, which is there was a witness blanket. So there were 100 people who were survivors of residential school who each sewed a patch of this blanket. And so rather than saying, oh, you have 1% copyright, you have 1% copyright, and what are the rights associated with that, they recognized that blanket as a living entity. Okay, so this is a non-human granted rights as a living entity. So I really want to look at those rights of the Magpie River and encourage you to look at those rights, because now if a non-human can be granted rights of personhood, and if a blanket can be granted rights of personhood, what if a database could be granted rights of personhood, which includes the right to grow? Right? What if it's a language database or an algorithm or an Indigenous-owned AI that is granted rights as a living entity or as having its own rights? So I kind of want to leave you with that seed. I'm encouraging different groups that I'm working with to tease the option of, oh, we have a database and it grows and it's not stagnant. What if it was living, or we honored it as being living? So I don't know what the implications are yet, but it seems legally sound. And again, if community members are upset, they can sue the database, which is really interesting. So we'll need insurance. And so, yeah, that's what I wanted to share with you. Thank you very much.